Kenny Wong is the head of intellectual property and information technology at Mayer Brown JSM right here in Hong Kong. Kenny, thank you very much indeed for coming in. Okay,
good morning.
I went through it. It's hugely complicated. It's not quite as simple and cut and dried as that. Now, Proview Taiwan and Proview Shenzhen may be sister companies, but they are separate legal entities, are they not?
Exactly.
Okay, so explain to me what the case here is that Proview has and the one that Apple has.
Well, I think the gist is whether Apple successfully purchased the trademarks from the true owners. And they approached Proview Taiwan in hopes of actually getting the registrations, which are in the name of Proview Shenzhen. Maybe I can sort of put it very simply. It's like if you wanted to buy a property, you went to a property and then you saw the husband. The husband said, oh, I actually own the property, I own the garden. And then you sort of did your search and say, oh, the house actually belongs to the wife. And then you go and tell the husband that I want to buy property, the garden and the house. And the husband said, oh yes, I can fix that. I'll be able to deal with that. I'll assure you.
So the house and the garden without consulting his wife, basically.
Exactly,
saying,
exactly.
Right.
And then at the end of the day, after the transaction has been completed, the wife said, no, I never agreed to sell the house. So if you
she'd be right if she's got the legal deeds to.
So if you want
who do you think is right? Because the lower court has already ruled in favour of Proview, hasn't it?
Yes, in China, yes. But then there is also a different decision in Hong Kong and the interlocutory proceedings.
Okay, let's not get too common. Let's just talk about the one in Shanghai,
yes,
which is up before the court today. Now,
yeah.
Which, in your view, which way is it going to go?
It's very difficult to say because it really depends on the evidence they put before the court. And I think the Proview people, they do have a respectable argument. So it all boils down to what sort of evidence Apple can produce to prove that they actually did purchase the marks from Proview Shenzhen.
Okay, could this result, and we've already seen it happen, iPads being taken off the shelves in China, could it mean the end of iPad sales in China altogether?
Well, the decision is about use of the trademark, use of iPad as a trademark. It doesn't really stop the sort of the machine itself, the device itself. So it means that if Apple has to, they can change the name of this particular tablet.
Or they could settle out of court, couldn't they?
Yeah, they can settle out. They can sort of, basically the settlement will be either acquiring the mark, paying an extra sum, or sort of having a licensing arrangement with Proview.
Okay, but Proview, if they lose, I guess it's business as usual, essentially.
Yes. Well, apparently they're in financial difficulties, according to reports.
Okay, but, you know, the thing is, what does he make of Apple's strategy here in taking on this Chinese company?
I think a lot of, I'm puzzled. I mean, a lot of lawyers share the same bewilderment as well, because we would have thought that Apple would have done their proper due diligence, and they definitely know who the registered owner of the mark is, and we can't understand why they haven't included Proview Shenzhen as a contracting party, because at the time when they approached Proview didn't know at all that it was actually Apple who was interested in acquiring the mark, and that's why they used a sort of different company to approach the Proview people.
You touched on Hong Kong. What's happening here with regard to this case?
Well, in Hong Kong, it's only an interlocutory decision, and the decision is about stopping Proview from transferring the mark to someone else. So it didn't really sort of go into the sort of merits of the case in the sense that they didn't really sort of discuss in detail all the arguments, and in that sense, the decision in Hong Kong is basically uncontested because the parties either did not appear or they were not actually sort of represented.
Okay, very quickly, I mean, I know you do intellectual property. Now, this is a separate point altogether. Many foreign companies really paint Chinese ones as ones which are copycats, they forge, cheat, and demand that China adhere to intellectual property rights and intellectual rules. You know, how out of sync or how in sync is that with reality on the ground?
Well, unfortunately, that happens a lot and it's still happening. I mean, there are a lot of individuals and even companies out there actually sort of filing applications, sort of tens of and even hundreds of applications. Obviously, a lot of them are actually third-party, sort of overseas, well-known brand names. And so they are opportunists, hoping that the true owner overseas may someday be interested and then come to approach them to pay a price for the registration.
Thank you so much for joining us, Kenny
You're
Wong.
most welcome.
Kenny Wong there, he is a lawyer, he's an intellectual property rights lawyer at Mayer Brown JSM.